Raja, le même qui plie dans rassemblé, à nous fiers de les boulonner. Ça m'étonne, laisse tout tomber, quand t'aimes, c'est qui vont arriver. Oh toi, nous et la confiance, oh toi, nous sentis bien.
Start by thanking all honourable members who have contributed to this important and historical debate. Some have made some pertinent comments, but I note with regret that others have not been able to resist the temptation of riding the hobby horse of blatant communalism to create division and hatred between our people. But before I refute some of the points made and correct some of the misunderstandings, let me make some general observations. Some honourable members seem to have forgotten why we are actually debating this bill on the third day now. I did explain, Mr. Speaker, sir, the background to this bill when I introduced it on the 4th of July. Honourable Ganu just also reminded us of this. But let me restate briefly the plain facts. We have been speaking of electoral reform since a long time now. There have been 7 reports which have been published and 4 since the year 2000. There have been several court judgments since, and all the judgments have urged us in no uncertain terms to bring some form of electoral reform to address the issues that have to be addressed. And I have said since many years now, Mr. Speaker, sir, that it is time that we identify ourselves as Mauritians and not as distinct communities living in different sections as if separate from each other in Mauritius. It cannot be right, Mr. Speaker, sir, that 46 years after independence, we still cannot say we are Mauritians when the election time comes. And I'm the first Prime Minister, Mr. Speaker, sir, to actually publish a document with concrete proposals for electoral reform. And as I've said, I will be circulating the bill, this bill, very heavy bill maybe, that's what they compare one to the other, but it should be published very soon. Now, if the bill we are debating today, what many misguidedly persist to describe as the mini amendment, has taken so many weeks to prepare, as Honourable Ganu pointed out earlier on, imagine how complicated the preparation of the electoral reform bill must have been. And when you see the bill, when it is circulated, you will see for yourselves. I wish, Mr. Speaker, sir, that honourable members realize how complicated and difficult it is to implement electoral reforms. I'm amazed how some, at least, honourable members, some people outside this House who love writing long articles or speak on radio do not actually have the remotest idea of the complexity of electoral reform and that it is such a major change that we cannot impose it on the people just like this. Mr. Speaker, sir, they seem to forget that we as politicians, we are the servants, not the masters of the people. We are here to serve the people. So we must have the opinion on major changes. The people of this country have a legitimate right to have their say on any major constitutional electoral reform. Mr. Speaker, sir, it is probably more difficult to introduce electoral reform than probably to climb Mount Everest. Very few countries have been able to carry out changes in the voting formula. You know, even the UK, the United Kingdom, the cradle of the first past the post system, has been attempting to reform its electoral system to elect members to the House of Commons for perhaps you'll be surprised, Mr. Speaker, so at least some will be surprised, for over 100 years. They have been talking of electoral reform, and still countless reports have been published, but no electoral reform. The latest one, which I'm sure some members must have read, was by Prime Minister Tony Blair. He had taken a manifesto commitment to bring electoral reform. He then set up an independent commission headed by Lord Jenkins in, I think it was December 1997. Lord Jenkins had a long time, consulted all sorts of people, and produced his report nearly 1 year later, in October 1998. Yet, in spite of this, nothing came out of it as for the other countless reports. There has been, in spite of the 100 years of discussions, no reform of the electoral system in the United Kingdom. 100 years, not 600 days, he's not here. 100 years. Canada is another example. Another robust democracy has been considering changes for a very, very long time. New Zealand, one of the beacon of parliamentary democracies, it has taken them over 75 years to reform its electoral system. Japan struggled for a number of years, long number of years, to reform its voting formula, while both France and Italy, after a long debate, they changed their formula, and then they reverted back to the old system some years later. It is clearly not an easy task, as some members seem to think. Otherwise, if it was easy, we would have done it since a long time. I wish also that honourable members had a quick look in the rear view mirror of history to take stock of how many attempts have been made in the past to introduce electoral reforms in Mauritius. The subject has been on the back burner for many years now. My friends who are today on this side of the opposition have tried, the opposition have tried on several occasions to take the bull by the horn. Unfortunately, it is the bull that has taken them. I do not know which part of the anatomy, but it's the bull that has taken them. I can only laugh when I hear criticisms from Honourable Jagannath and Honourable Buddha, because they belong to the party that deliberately stifled any attempt to reform the system. I was leader of the opposition then. The Honourable Leader of the Opposition was Prime Minister. He noted that for the first time, the leader of the Labour Party was for reform. You were a majority in government, but you deliberately boycotted, stifled, and made sure that it never happened. They have had many opportunities to do it, but systematically, they found false excuses to shrink away from their responsibilities on this subject. Now, I'm sure honourable members realize that there is no ideal electoral system. It doesn't exist. There is no perfect formula. If there was, as I said, all countries would have embraced it. And like football, Mr. Speaker, which is the same worldwide, as far as I know, there is probably as many electoral systems in the world as there are countries. Even in some countries, in the same country, in France, for example, in the UK, there are many voting formula that coexist depending on the election that is being held, whether it's the House of Commons, whether it's the Assemblée Nationale or regional assemblies in Wales or Scotland, whether it's the European Union. I can go on giving you examples. And I wish, Mr. Speaker, that honourable members had carefully read the consultation paper that I presented on the electoral reform on the 24th of March before starting making wild and unwarranted statements on such a complex issue. I honestly think they haven't. Because, Mr. Speaker, sir, I explained. There have been numerous reports on electoral reform. Constitutional experts have been advising. Even when they were in government, there was the very eminent person, Albie Sachs. I also, after seeking advice, not from one, but from many constitutional experts, we tested the hypothesis against for the new proposed electoral, against the data that we have since the 1967 elections. That is why it took me longer, because we need to test these things. And then, after careful analysis and reflection and discussions, we published the consultation paper on the 24th of March of this year. Now, these proposals, I must point this out, because I see a confusion. These proposals for electoral reforms in the bill, they go well beyond removing the need to declare one's community to be eligible to stand as a candidate in a general election. It is more than this. It is far more than this, Mr. Speaker, sir. It goes beyond just removing, if I may put it that way, this shadow of communalism from our Constitution. For it proposes the introduction of a dose of proportional representation to tamper the excesses of the first-past-the-post system, to reflect fairness and equity, while ensuring stability. And it does so by abolishing, it will also abolish the need to declare one's community, because it doesn't actually abolish the best rule of the system, as Honorable Selmia has been saying, but by subsuming it. Honorable Ganu even pointed out. I don't know how, why, if people had read the Carcassonne report, even him, it's a small report, he said he's not saying we should abolish the best rule of the system, but we should find a way of subsuming it differently. That's what he said. Now, it is also this electoral reform bill that will be circulated with. It is not just this. It is also a major, major step forwards for gender representation and a real advance. I see many ladies are here. Real advance for women in this country. A lot of intense work has been done on the bill, as Honorable Ganu pointed out. I want here to thank the Attorney General, Honorable Ganu himself, the Solicitor General, his deputies, Mrs. Narayan, Mr. Sitaram, Sir Victor Glover, the former Chief Justice, and Mr. Ramastanen, who did tremendous work for all the hours they put into this to come up with this electoral reform bill. This is what is called selfless service for a cause. As I said, Mr. Speaker, sir, the bill is practically ready. Except on second thoughts, there are some alternate proposals that we think could be included to give parties options to choose from. For example, we think parties can have the option of double candidacies. If you want it, if you don't want it, don't use it. We also think that for the 20 additional seats, there could be two lists, a list A and a list B, 14 to be chosen from list A, 6 from list B, by party leaders for the list B. Or alternatively, we think it's possible to have only one list of 20, but from which 6 will be chosen from the leaders. In other words, the two alternative mechanisms will produce the same end result, but look slightly different. This is something, there's an option that we are discussing, and maybe we will look at it better, and then we will, if need be, put that in the bill. But as I said before, Mr. Speaker, even though the bill is practically ready, I believe strongly that the people of this country have a legitimate right to examine it, examine the proposals, and then give us a mandate to bring electoral reforms. And as I said, Mr. Speaker, this bill will be even more complex than this bill that we have brought. And you have seen, Mr. Speaker, sir, you have seen for yourself the passion that has been generated by this, what they call the mini amendment, which it is not. Now, it is important, I think, for people to know exactly what structure we're going to propose so that they can endorse it at the next general election. And let us not forget, Mr. Speaker, sir, we've had judgments over judgments from the Supreme Court, our Supreme Court, from the Judicial Committee of the Privy Council since 2000. And they've all been urging us to act. And Résistance et Alternative have been asking the courts to allow a candidate to stand in general elections without having to declare his or her community. As I said, Mr. Speaker, sir, they did not ask for full-blown electoral reforms. Neither were they asking, have they been asking for the abolition of the best ruler system. What they are asking for is to allow a candidate to stand but not declare his or her community. And this is less than what we are proposing in our bill. The United Nations Human Rights Committee has pronounced itself. They have found that we are in violation of Article 25B of the Human Rights Convention. And they have said that we have a duty as a state to provide an effective and enforceable remedy to the violation of Article 25B of the Covenant, and that we are under an obligation to avoid similar violations in the future. The words are plain. I don't think we need to translate it now in a different language. Furthermore, let us not forget, there is the last judgment of the Privy Council, Judicial Committee of the Privy Council, which concludes by saying that if the issues cannot be resolved politically, they may be raised before the Judicial Committee of the Privy Council by the applicants as a constitutional challenge, which means it will not take ages. They will look at it very quickly. Now, Honorable Semia, leader of the FSM, says we can ignore the declaration of the United Nations Human Rights Committee as well as the Judicial Committee of the Privy Council. I don't know why, unless I misheard him, I heard him say that, the Prime Minister is saying there's no money. That is not what I said. Let me enlighten him on this issue. The declaration of the United Nations Human Rights Committee, it is true, we knew it from the beginning, they cannot actually enforce us legally to do what they're saying we should do. They have made a declaration, but there is no legal force behind. But there are consequences if you ignore it. And the European Union will take sanctions against us. I was recently, Mr. Speaker, for the European Union Africa Summit in Brussels. I spoke to many people, not just to one person. And they said clearly to me that what they will do, certainly they will do, they will withhold all the financial assistance we receive from them. 2 days ago, I was opening an ethanol plant for Omnicay. They haven't help through the European Union. That would go. All these measures d'accompagnement that we will receive, all this will go. That has been made very clear to me already when I attended this EU-Africa summit. So it beggars belief. I suppose you didn't realize this, but it beggars belief that you say the honourable member says we can ignore it. And I don't need reminding honourable members that the Judicial Committee of the Privy Council is our ultimate court of appeal. We cannot just ignore them. And if you read the words in the conclusion of the judgments, they are practically inviting the members of Résistance et Alternative that if they do not get satisfaction through the political leaders and the issue is unresolved, then they should come back, they can come back to the Judicial Committee of the Privy Council with a constitutional challenge. I know when the case was in front of them, they practically felt they wanted to make comments, but they did not. But they certainly will next time. So it is absurd to say that we can ignore them. Neither of them can be ignored. Doing nothing, burying our head in the sand like the ostrich, is not an option. That is why, Mr. Speaker, sir, we intend to bring the electoral reform bill. We think we need a mandate from the people. It's nearly finalized. A lot of work, as Honourable Ganu has been said, it's a huge bill, a lot of work in it. And I can see what kind of questions, all sorts of questions will be asked. But in the meantime, we have to do something about the declaration of the United Nations Human Rights Committee, and also be careful of the Judicial Committee of the Privy Council, which I think they well realize. That is why we are debating the transitional amendment bill. One is different from the other, but we need to do something now. This is the minimum that has to be done before we get a mandate for the full-blown electoral reform. Now, Mr. Speaker, sir, concerning this bill itself, and to respond to some of the misguided arguments from some honourable members, let me say this. If honourable members had really perused our Constitution, but also had read carefully and fully understood the significance of, in fact, the first schedule, especially paragraph 5 of Schedule 1. What does the first sentence say in that paragraph? Let me just quote the one sentence. What does it say? It says, in order to ensure a fair and adequate representation of each community. These are the operative words, Mr. Speaker, sir. Fair and adequate representation of each community. That what they mean by each community is that each of the 4 communities, which is, in fact, I think described in paragraph 3 of subsection 4 of the first schedule. It is clearly defined. And that is part of our Constitution. We just cannot ignore it. This is also well argued by the full bench of our Supreme Court in a landmark judgment in 2005, and I think the Attorney General has referred to it in his speech on Monday. I note also that many members, even those from the legal profession, who are expected should know better, have often spoken in complete disregard of this fundamental provision of our Constitution, as if it did not exist. They've isolated it completely. In the case of Honorable Boda, in some cases also, they have made proposals that are so aberrant and misconceived that we cannot, actually, it would make an utter mockery of our Constitution. This, Mr. Speaker, sir, in spite of what some people are saying, is a giant leap forward that we are taking today. It is the first time in the history of our country that a government is bringing a bill to give the option to our citizens not to be disqualified as a candidate at a general election if they do not want to disclose their community. And I'm glad and I thank the Honourable Leader of the Opposition and the MMM, because they have seen where the national interest is, and they have helped. They have accepted to him, and that's why we work together. I see a lot of you are complaining why you were not called, but you've already said you're against all these things. So why should I open up? In my document, in the concept document, I say, we're not going to open the whole debate to everybody who has now an opinion again. If we know they're entrenched on the opinion, we're not going to. But here, the two parties have decided to collaborate. And the MSM, forget, they have been in office for over 60 years, for around 16 years, I think. And why did they never thought of introducing this historic legislation? You know what I say? All talk and no walk. Mr. Speaker, sir, on juge un maçon au pied du mur. I am walking the talk, while others have not even bothered to talk the talk. This is the difference between conviction and hypocrisy. This is the difference between faith in the Mauritian nation and a distorted view of history. This is the difference. And I wish that honourable members appreciated the context, the circumstances, and a sense of history, which is key to understanding the amendment being proposed. I think the Honourable Leader of the Opposition has given the context in his speech. Honourable Ganu also, I think Honourable Utim also, they've all given an idea of the context of this bill. 46 years after independence, as I've been saying time and time again, it is time for us to move on and consolidate national unity and our national identity as Mauritians. Now, I've heard some people say, you're going to change the law and you think communalism will be over? Of course not. Who said that? But at least in your constitution, which is the highest law of the land, you remove even the shadow of communalism. And because if you had read the document and had bothered to go to read the original report, I told you, look at what the other constitutional experts have said. Look at what De Smith said in 1964. This is precisely what has happened. This is precisely why you see Honorable Perrault uttered the nonsense she uttered. This is precisely why, because the mind thinks that way now. I don't think she's doing it deliberately, but she's thinking that way. Or maybe I don't know, but she's thinking that way. That is the problem. We must, Mr. Speaker, sir, resolutely move forward and construct a nation state that can fulfill the aspirations and expectations of our people, especially the young people. Go and see what the young people are saying about you. You can write on Facebook, you can do what you want. Go and see what they're saying. I'm extremely sad, I must say, Mr. Speaker. Sad to have heard some of the speeches that are really, really fit for another age and another century. Really, I thought I was in the 18th century or 16th century, God knows. Rabble-rousers, what I call ethnic entrepreneurs, who desperately want to lead the match, to spark a fire, and to fan the flames of communalism. There's nothing more dangerous at what the PMSD have done. There's nothing more dangerous. I thought I was looking at the PMSD of before independence. I can't recognize Honorable Juval. Different, completely different. Communalism in his head.
Yeah, on a point of order, I'd like the Prime Minister to point out in my speech what actually he thinks was communal. He's saying that I raised this communalism. I have the Hansard here. I took the trouble of rereading it. I would appreciate if the Honourable Prime Minister could indicate which paragraph.
Mr. Speaker, sir, the whole bloody speech has somebody said. You can see the mindset. You can see the mindset. He really thinks that. And you think when Honourable Perrault spoke without his permission? You don't agree with what Mrs. Perrault said? Look what she said. I will come to what she said in a minute. I wish, Mr. Speaker, sir, honourable members, any MP with a modicum of intelligence would have already realized that under normal circumstances, it is impossible to allocate the 8 additional seats if a returned candidate has not declared his community. You don't have to be a genius to know this. You don't even have to be an expert. And this is crystal clear from the judgment of the Supreme Court and from what has been stated by the Judicial Committee of the Pre-Council. It's crystal clear. The two work together. Yet, and this is why it took so long, Honorable Ganu knows this, and I would have hoped the others knew. It took so long because here, this is precisely what we have attempted to do. In other words, very difficult thing to do. It is not a perfect solution, but at least it reconciles two opposite objectives. I hope honourable members understood also the fact that this amendment is an integral part of a wider constitutional amendment to reform in depth our electoral system. As I say, the bill will be ready very soon. Now, you know, it is very easy, Mr. Speaker, sir, to criticize. Very easy to criticize, but very difficult to make constructive proposals. All along the debate, there have been many criticisms of what is being, many criticisms. And yet, on the other side, not one meaningful alternative proposal to address the issues as such, except from the leader of the honourable leader of the opposition and the MMM. Nobody else made any meaningful alternative proposal. A couple of proposals have been made, but they're so preposterous that they're not even worth the paper from which they were read. Not even worth this. I'll give you an example, Mr. Speaker. I'm referring to the points raised. Honorable Boda argued that we should allow party leaders to choose the BLS as it is now. And obviously he doesn't realize that this as it is now goes totally counter to the letter and the spirit of the Constitution that speaks of a fair and equitable, adequate representation of each of the 4 communities. And this, at the moment, is objectively determined by the BLS formula, which the Electoral Supervisory Commission uses. I can't imagine that a proposal like this should emanate from a lawyer. Honestly, I can't. I'm not trying to be unkind, but I can't. I wish honourable members would also acknowledge that we cannot hedge every possible electoral outcome. It's impossible. There is no perfect electoral system that can do this. It's impossible. There can always can be an element of unintended consequences in any proposal. Even in the current, Mr. Speaker, even in the current system as it is, there are risks of some communities not being represented at all or being severely underrepresented in Parliament, and this happens. Any alert observer would have seen this already. There is no perfect formula. We need some ground rules to make the system operational in the overwhelming majority of cases. Now, as I say, it's not possible to hedge each and every conceivable scenario. If you remember, I referred to the 1991, I think, judgment of the Supreme Court from former Chief Justice Glover, ex-Chief Justice Lala, and I think Justice Habet. They even pointed out in this. Even us, we have made, sometimes you cannot see the unintended consequence that comes before you. They make reference to the proposals of Stonehouse, which was A, B, C, D, E. And somehow they say, somehow proposal E wasn't taken on board when the Constitution was made. And they speculate. They say they can't think it's bad faith, either from the colonial power or from people here, especially from the colonial power because they were deciding everything. They don't think it's bad faith, but what probably happened, nobody ever thought that in Mauritius there will be one day, if you look at the elections, how they have been, that one day there's a possibility that there will be a 60-0. It has happened twice, and as I said, I'm looking forward to it happening a third time very soon. So it can happen. The Honourable Leader of the Opposition say, jamais 203. Murphy's Law, what won't happen will happen. I wish honourable members also understood that the best rule of the system will still be in place for the next general elections. I can't understand why Honourable Semia say we are abolishing it. Speaking of a conspiracy to eliminate something that will continue to exist is the height, Mr. Speaker, I'm sorry, of disinformation and demagogy. Honourable Semia is repeatedly saying it. That myself and the Honourable Leader of the Opposition, you put up posters that we are abolishing the Basuda system, and worse, you bring religion in it, you say in the months of Ramadan, these posters. How can you possibly do something like this in this day and age? That is the price. That is the price to win power. If that is what we have to do, win power, good luck to you. But, Mr. Speaker, sir, anybody again with a little knowledge, understanding of the bill, and a paucity of legislative knowledge would surely have recognized that the best rule of the system will function at the next general elections as it has since 1967. Equally, I can tell you the objective of the BLS system in terms of parliamentary diversity and rainbow representation will remain in the reform that is actually being finalized. What we have said, and I think Honourable Ganu explained it very clearly, I could not put it more clearly than he did, that the objective of the BLS will remain. We're not abolishing it, but the mechanism will change. That is what we are doing. It will consolidate democracy. It will consolidate national unity in addition to being fairer to women, and also a point that may seem they seem to take lightly. Women are more than 50% of the electorate. We have to take care of our women folk. I'm sure they would have noted who are those who just do not care. They will come election time, they will get this and that, but they do not actually care, because if they care, they wouldn't say what they're saying. Now, some honourable members have tried to stir up the communal, I must say communal feelings, by suggesting that this bill will deprive the Chinese community, I'm going to say it as it is being said in some quarters, from representation in our parliament. Now, some have said, Honorable Pravin Jangat has said, that this system will deprive, the Hindus will lose out. Others are saying the general population will lose out. Now, nothing could be further from the truth, Mr. Speaker. How can this happen? You just have to look at the statistics to know this. In fact, let me say clearly, in fact, if you look at statistics, in every election since independence, every one of them, there has been an MP from every community in Parliament, and at least one MP from the Chinese community. Every election. The Chinese community, none was selected through the BLS system since 1967, precisely because they are not underrepresented. Now, what happened in 1948, because I see some of them in the Réunion Nocturne or whatever it is, obscurantiste, I used to say. They are saying, you see, they're finishing this community. All this is being said. I have the reports. Now, they allude to the fact that Honorable Leader of the Opposition has said in 1948, look what happened. The Muslim community did not get a returning member to Parliament, and that the scenario can, they say the scenario can repeat itself for the Chinese community. This scenario will not be repeated, and the reason is very simple. In 1948, as the Honorable Leader of the Opposition explained, the number of voters increased because I thought they had learned how to write their names. But still, a majority of people were not voting. There was no universal suffrage in 1948. Now, with the advent of universal suffrage, the Muslim community has always been represented in Parliament. And the same goes for the Chinese community. But because, Mr. Speaker, sir, because there are people, what I call pyroman, I think you rightly said, have similar doute. That is why I'm bringing an amendment, which has been circulated, I suppose you've had it at committee stage, to remove any shadow of doubt which might have been created for obscure purposes or cheap political gains, God knows what. Just in case, they still. We are maintaining that what we proposed is there, but added a new section 42B2 just for the avoidance of any doubt. And I repeat it, Mr. Speaker, sir. Our Constitution and our electoral system need to evolve to adapt to changing times. Societies are never static. 1968 is not 2014. In 1982, as the Honourable Leader of the Opposition said, he's right to have said it, it was the first step which was taken to do away with the mandatory collection of data about a citizen's community in the census. It was the first step. I said even it was a far-sighted decision. But as he said, I can understand. They did not abolish or subsume the BLS because they felt they had no mandate, just like what I'm saying now. They didn't have a mandate for this. But by this decision, when we stopped the census, it was clear that the seed of the eventual problem was sown and that the BLS inevitably started living on borrowed time, because a time will come when it can't respond to the criteria. We did not need the United Nations Human Rights Committee to tell us this inescapable fact. But we have to look at reality and grasp the bull by the horns, as I said. Now let me, Mr. Speaker, sir, respond to some of the points raised by honourable members. And I shall take this opportunity to clear the air. I think, on some unfortunate insinuations, at least, that some members are made. First of all, they say, some have said that the bill has been drafted in an infelicitous, inappropriate, in other words, manner. And that clause 2B1, which relates to the determining of the appropriate community of an elected member who has not declared his community, and allocation of additional seats after the next elections, is pregnant, to use the word, with ambiguity, and is a clear intention to mislead. Now, I totally reject this unfounded allegation, unless the honourable members want to play politics and to stroke, as I said, the unwarranted fear in the minds of some people. I must confess, Mr. Speaker, so that it was an extremely difficult bill to draft. I do agree, because as we wanted to accomplish two aims that are contradictory in our Constitution. How do you allow the option for candidates not to declare the community, while also to ensure that the allocation of the additional seats is consistent with the provisions of the Constitution for a fair and adequate representation of each of the four communities? This is where the dilemma lies. Now, those who understand mathematics, I don't think you need additional mathematics for that. You should know, they should know, that you cannot have two unknown formulas, two unknowns in one formula. You cannot have two unknowns in one formula. You must absolutely freeze one of the unknown to be able to move the other unknown. Otherwise, you can't have. I don't know whether I get the impression I'm not making, this is not being grasped, but never mind. We did not have, as I said, Mr. Speaker said. But this is the challenge we had. There are two unknowns, they're contradictory, but in spite of that. And that's very Mauritian. We put our heads together and we found as best a solution as can be found. There is absolutely no intention to mislead anybody. Any honourable member who says so either has not understood it or is deliberately trying to play on the fears of the people. One honourable member mentioned that the ESC, I think it was Honourable Pravin Jagannath, this is when the leader of the opposition objected, that the ESC will determine, I know he has withdrawn the word, Mr. Speaker, sir, but I still want to clarify it, if with your permission. He said that the ESC will, no, I'm sorry, I'm referring to another member. One member said that the ESC will determine the community of the returned candidate who has not disclosed his community. One of the members said that. Now, how can that be? It's absolute nonsense and plainly untrue. There is no question of determining the appropriate community of an elected candidate who has not declared his community, unless he's referring to the original draft, where one lawyer mentioned, you know, if that is the solution, we'll have to look at the census, the birth certificate, and all this. But that is gone long time. This is not in the bill. You're reading an old bill. Mr. Speaker, sir, how can we assign a community to an elected candidate who has himself or herself decided not to disclose his community? How can we actually do this? It is very clear, therefore, that either it has been misunderstood or there is a twisted interpretation with a deliberate intent. They intend to mislead people. And some members have asked what mechanism will be used to determine the best leaders. And this is where Honourable Pravin Jagannath especially said, the ESC has already predetermined the communities who will benefit from the BLS. Mr. Speaker, sir, I really, honestly find this baffling, to say the least. You know, you may wish to note that Mr. Soubron of Résistance et Alternative, he gave an interview, and you know what he said? He said he cannot understand those who say the mechanism is not explained, as it is very clear. Mr. Soubron has clearly understood it. The mechanism is there. I know he had to withdraw it, but I still say it is not true. It is not as straightforward as some appear to think. That could be true. First of all, Mr. Speaker, sir, just to make, I don't know, you can't be plain, huh? Who can predetermine the results of an election? who can predetermine who the candidates will be in the election? That is something that happens afterwards. First of all, the leaders or the parties have to decide who are the candidates. Then they have to be elected. And then you get the results. You cannot predetermine anything in an election. I know, but I just want to clarify, at least enlighten him a little bit, just in case he probably still has doubts. He will probably go and say the same thing in his opinion nocturne. But I thought if I clarify his mind, maybe he will understand. You have to know that the election results have to come out first. It is only then that the best losers will be chosen. This is elementary. You cannot choose the best loser before the election. It's impossible. Secondly, Mr. Speaker, so once the election results are known, I think many people do not understand this, I must say. It is complex. The Electoral Supervisory Commission then decides the first 4 best loser seats on the basis of which communities, irrespective of party, completely irrespective of party, which communities are underrepresented according to the 1972 census, because that is the last census. Now, as I said, when a party or a party alliance or whatever, they're filing candidates. Already, Mr. Speaker, sir, it is a fact, let's not forget, it is a fact that there can be overrepresentation of one of these 4 communities when you're filing the candidates yourself. There can be. Then clearly, if candidates from this community are elected, clearly they already are going to be represented according to the 72 census. And therefore, they're not going to get the best of the seats. The best of the seats is for the communities which are underrepresented. And if at the very start, when the parties file the candidates, a community itself, when you're filing, is underrepresented, then it is clear that they will benefit from the best of the seats. Because this is precisely why the best of the system is there. The first 4 seats, Mr. Speaker, sir, as I say, they are there to correct the underrepresentation of one of the 4 communities which is defined in Schedule 1 of our Constitution. That is waiting Schedule 1, Paragraph 5, Schedule 1 of our Constitution. Now, this explains why, if you want it plainly, this explains why you have had best of the seats going mainly, but not always, but mainly to the general population, and then a bit less to the Muslim community. If you look at the patterns, you will see it. I'm not inventing it. This also explains why the Sino-Mauritian community has never benefited from a best of the seat since the 1967 elections. Never. Go and see. Because they were not underrepresented. That is the reason. And the chances of this happening is practically 0. Hypothetical. But you can say it is hypothetical. But as I say, Mr. Speaker, sir, just because this doubt has been created by some, I want, in order to make it absolutely clear, I have brought in this amendment which has been circulated. The amendment is not one of substance. Again, I have to explain this. It is not one of policy change. It is a clarifactory one. It is clarifying, just to make it clear, absolutely clear, this is what it is done. It is doing. And Mr. Speaker, sir, I know many here clearly do not even understand how the best of the system works. It is clear that they don't understand. Because once the first 4 seats have been allocated, the second set of best loser seats are allocated on the basis of the appropriate party and underrepresentation of communities. And this is with a view to redressing the imbalance in the majority caused by allocation of the first 4 seats. Because the first 4 seats could easily go to the opposition, so you have to rebalance the will of the people so that it can happen. Because then you don't transform a party which has won an election, make it lose the election. That is why the whole system is like. And a constitutional amendment was made in 1992, in fact, to restore the balance in respect of the second set of 4 seats. And they said, irrespective of community, that is the amendment that was made, in case candidates from the appropriate underrepresented community are unavailable, as all have been rejected. Yeah, all have been elected. As I said, Mr. Speaker, in the judgment of 1991 with the former Chief Justice Glover, at the time he was Senior Penal Judge Lala and Justice Ahmed, they pointed out this loophole that I explained earlier on, and that a government which has been elected by 30-30 can become a minority 30-34 if this is not corrected. And that was only corrected in 1992. And as the result of this amendment in 1992, 2 MPs from the Hindu community, to clarify Honorable Praveen Jagannath's thoughts, it is only then that 2 members from the Hindu community were appointed best losers in the 2000 general elections. Even though, even though the Hindus were statistically not underrepresented. They were not, but because for the imbalance problem, they got in. Prior to this amendment, it's good also, you know, if you know the history of this country, if you look at what has happened in this country, you will see that the Hindu community only benefited from the best loser system. They got 1 best loser seat only in 1967. Only then. Because then it was underrepresented according to the 1962 census. People were voting on party lines very often. That's why you will see. It was not on communal lines as it is sometimes now. So it is important to note also, Mr. Speaker, sir, that is another thing that I think some honourable members actually don't understand. Not all 8 seats are determined at the start. It is never like this, the BLS system. It is one after the other, step by step. Once the first seat is allocated, the whole exercise has to be redone. That is the exercise on who is underrepresented. It has to be worked out again. Then only the second seat is allocated. That is why a lot of people can't understand it. So, you can see, Mr. Speaker, it is a complex system, the best loser system. You have 3 conditions you have to satisfy. First of all, it starts with the appropriate community, which is underrepresented, irrespective of party, and they get allocated the first 4 seats. Then they have to look at the appropriate party, with the appropriate community, and then it has to ensure as far as possible that the majority of the winning party or alliance is not compromised, thereby changing the results of the election or even compromising it as far as possible. So, as I say, it is a step-by-step recalculating every time the 1 seat that is allocated. That is why also, Mr. Speaker, sir, that the allocation of seats can be erratic, can be illogical, can be irrational. Not just the only reason. That's one of the reasons. You know, there's an example, I hope you won't mind my saying it, there's an example which speaks for itself and it illustrates very clearly what I've just said can happen. The case of the Honourable Leader of the Opposition himself in 1987. In a way unfairly, but that is the system. Because in 1987, I'm sure he remembers, Mr. Regis Finet, who was in the PMSD, had polled 13,541 votes. He had got 47.4% of the votes. While Mr. Béranger had got polled 15,332 votes, compared to 13,541. He had polled 48.4% of the votes. Finet had polled 47.4%. But he did not get the seat. It was Finet who got the seat. Because the seat, when the seat had to be allocated to a member of the general population, then, as I explained, Mr. Speaker, sir, they look at the community first and then community plus underrepresentation. Mr. Béranger was At the second time, he was in the appropriate community, but not in the appropriate party. That is why this happened. It has happened to us also. In the case of Clarel Maleb and, I forget his name now, he's passed away. Kandau. Both of them in the same alliance, both of them from the general population. Clarel Maleb gets a much higher percentage vote than Kandau, but Kandau gets in, not Maleb. And this was because different symbols. Now, Mr. Speaker, sir, and that seat that Mr. Béranger did not get, look at the percentage, because he was then in the appropriate committee was not what it happened then, it was not the general population, but the Muslim committee. And therefore, it is Mr. Pirani of the same party, who had polled 44% and 12,999 votes. He is the one who was selected, in spite of the fact that Mr. Béranger had polled 48.4% and over 15,332 votes, I think. And they both belong to the same party. Go and read the document, please, because there are other examples I've given in this, precisely because of this. And I must remind honourable members, the mechanism is the same, actually the same today, and still based on the 1972 census. So you can expect, again, some erratic, illogical, and irrational selection to occur. Now, Mr. Speaker, sir, there was another point made that the meaning of the average number of returned candidates for each of the 4 communities to be worked out from clause 4 to B1 is by itself, as I say, is a simple exercise. It's not a difficult exercise. There is no ambiguity at all. These figures are publicly available. That is what Mr. Soupon said. They are available. You just go in there. You can get these figures. So whether maybe some honourable members do not agree with the formula, but that is a different matter. But to argue that there is a shroud of mystery and deliberate attempt to hide the figure is actually totally irresponsible, Mr. Speaker, sir, if not plainly stupid, unless they have any hidden agenda. Now, the figures also cannot be misleading. As I said, many people have already worked them out. And they are objective. They are published by an independent institution, not biased. It is there for you to see. Now, there was an allegation, Mr. Speaker, sir, that the proposed formula could distort the allocation of additional seats to an appropriate community. Again, Honorable Pravin Jagannath said that. He said that if, for example, so many candidates, maybe 10 candidates from a particular community, I think he was referring to the Hindu community, who decide not to declare the community and they are elected, as a result, that community will be deemed, therefore, for the calculation purposes, to be deemed to be underrepresented, and that the ESC will then have the obligation, according to him, to allocate the additional seats to candidates who have declared themselves under that particular community. Now, first of all, Mr. Speaker, sir, who in his right set of mind would do something like this? You want to start communal problems in this country. It would be totally irresponsible to do this. But as a matter of fact, the honourable member is proving exactly the very essence of clause 4 to B1. The very clause that is criticizing, that is why the clause is there. Had we not introduced that clause, that specific clause, had we not introduced it and simply replaced the shall by may, then that possibility might have existed, not being allocated to the right community. But clause 4 to B1 is included precisely to prevent such an occurrence. If one or more elected members have not declared the community, and to avoid what the honourable member himself has given as an example, the average figure mentioned in the clause shall apply. In other words, it will ensure that the allocation of additional seats do not go against the provision of the Constitution, that is, for a fair and adequate representation of each of the 4 communities, which is the whole objective of paragraph 5 of the first schedule to the Constitution. And as I say, this has been emphasized. If you just read the judgment of the Supreme Court, you will see it there. I'm not inventing this. And as I say, Mr. Speaker, sir, we all know who have benefited from the BLS over the years, We know accurately the community belonging to all the 32 returned candidates at every general election since 1976. Now, Honorable Jagannath again said that the calculation in the clause would replace the 1972 census. If I heard him right, I was here. But again, this is not true, Mr. Speaker. So we simply cannot replace the census of 1972. We just cannot do it. We don't want to do it, but we also cannot do it. Even if we are unhappy about that 1972 census, it will still be used to allocate the additional seats at the next general election, and there is no other alternative. There is no other alternative. Wait, I'm coming to this. There is no better alternative, Mr. Speaker, sir. Now, some of the proposals made, Mr. Speaker, sir, have, by some members, they actually go against the provision of our Constitution. But I shall come to this in a minute. Now, I think what is happening, Mr. Speaker, I might be wrong, but I think what is happening is that the honourable member is unfortunately mixing two very different statistics. I think that is what is happening. That of the ESC, which they use to allocate the BLS seats, the population breakdown into 4 communities as obtained from the census of 1972, and also the second set, the community mix of the 62 elected members are the result of the first past the post elections. Results are known. The first one will not change in any way at the next election. I will come to your criticism in a minute. That is, the ESC will still use the 1972 census. Because if we follow your argument, then what do you want us to do? To abolish the BLS? Say it. You can want this. But you don't. Nobody here, well, at least we don't want to abolish the BLS. If we don't want, then we have, as I say, you cannot have 2 unknowns in one formula. That is why the 1972 census is there. But his confusion, I think he's confused because it is betrayed when he himself criticized such a use later in his speech. That is what I think you're listening. Now, Mr. Speaker, it cannot be both. Either you keep it or you change it, but it cannot be both. And as I say, for lack of a better alternative, until the full electoral reform is introduced, and we have said it will be for one election. So who are these crooked minds? I don't know how they bend. Monsieur le Président. Who can think of how they can make the thing not work and create problems. Who are these people? We are seeing who they are. But let me say, Mr. Speaker, so let me stress that the second statistics will not change at all if all the returned candidates have declared the community. And that is what I think they are trying to do from what I understand. If everybody declares and they are elected, the BLS, as we know it, will be exactly applied the same way as provided by our Constitution. It is only in the case of one or more members not declaring the community, not declaring the community and then being elected that they will have to use precisely the formula that we have put, and we think is the best formula available. Mr. Speaker, sir, again I said don't forget the mandatory requirement of the Constitution to ensure a fair and adequate representation of the 4 communities. It is essential. Now, many have been saying and wondered why about the alleged omission of the specific mechanism to allocate the additional seats. But again, Mr. Speaker, I just explained, Mr. Soubon has grasped this early on. The mechanism is there. But it should be pointed out that in the existing legislation, the process for the allocation of BLS seats is spelled out very clearly, while the details of the way it operates are carried out by the ESC. In fact, that's why I'm saying I think many people are not grasping the mathematics that drive even the allocation of the first 4 seats. I think that is where the difficulty is. The distribution of the second 4 seats is much more complicated, as I said, and at times we've had to go to court to seek an interpretation from the courts. What we are proposing, Mr. Speaker, sir, is in this clause is much, in fact, simpler to compute. It is an average that anybody can work out, can calculate, and then the ESC will proceed exactly as it does today. As rightly pointed out by Mr. Soubon, Mr. Speaker, sir, and many others who have done their homework, It is very simple to compute. There is no great difficulty. And as a matter of fact, I see many observers have already worked out the figures. I understand that Honorable Juval somehow, I don't know, I think he has understood, he has given the figures, I think he has understood the system from what I see, because he said, I hope it is this, but I hope it is not that. It is not that, it is this. He's a chartered accountant, so he should be able to, and former Minister of Finance, he should be able to understand this. And he has understood it. I give him credit for this one. But unfortunately, not all former Ministers of Finance have understood it. Eh? I forgot you were. I am therefore at a loss to understand what some honourable members want to convey by saying that the formula is not in the bill, when in fact it is there and it can be easily computed. It is rather unfortunate, Mr. Speaker, sir, that some members of this House have tried to give a communal twist to the computation of the allocation of the seats to imply that in one case, two given communities will be allegedly penalized, while in another case, two other communities will be penalized. In other words, all four, A and B. But, Mr. Speaker, sir, it is a well-known fact. It is basic, in fact. It is a well-known fact that in a what we call a zero-sum game, everybody cannot lose. That is why it's called a zero-sum game. Not everybody can lose, but they are saying everybody will lose in this zero-sum game. This is convoluted reasoning that, for me, I can see now there's a clear hidden agenda for them. Mr. Speaker, sir, as mentioned earlier, we know which communities have benefited from the BLCs. What is the committee of the 62 candidates elected at each election since 1976? It all depends which of the communities are underrepresented, which candidates you have chosen, and it starts the day your party or alliance files the candidate. Now coming to the point of Honourable Jagna. He said, one time he said they are opposite, but anyway, let's come to the point. You've just said it again, that the 1972 census is still being used, and therefore it is in violation of the United Nations Human Rights Declaration. But he also says that this calculation would replace supposedly the 1972 census, again because we are going to violate. Now, it's a contradiction. Either we're using it or we're not using it. But let's say you're coming down to the violation of the covenant. And he says he finds this scandalous. But let me clarify this in simple terms. The calculation, Mr. Speaker, sir, is not replacing the 1972 census. It is not. It is the latest census that we have. And the BLS, which we're not abolishing either, as Honorable Selmia has said, depends, as we know, on the census. And the one that we have, the latest, is the 1972 census, from what Honorable Selmia said. If you follow the logic, then you want us to abolish the BLS yourself. You should put a poster saying you are abolishing the BLS. You want to abolish the BLS, not us. Now, if Honorable Jagannath had read the findings of the United Nations Human Rights Committee carefully, he would have seen that the cause of action of Résistance et Alternative, what did they say? They said that the state of Mauritius was in violation of Article 25B of the Covenant by depriving the candidates from standing at a general election if they do not declare to which community they belong. And the ESC and the courts were right. This is the Constitution, because the BLS system depends on the census. So if you not declare, they cannot allow you to stand because it's difficult to calculate. Now, if you read the declaration of the United Nations Human Rights Committee properly and put it in its context, I don't know why you didn't put it in its context. I think that's where the mistake is. What does it say? It says asking a candidate at a general election to declare to which of the four communities he or she belongs does not, and if you refuse to accept his or her candidature, then it's a fundamental breach of his or her human rights, and you are in violation of Article 25B of the Covenant. 2, it says, you have to reconsider whether the community-based electoral system is still necessary. 2. And thirdly, he says, if you do, then you must update the 1972 census, which we knew. We didn't need them to tell us this. Now, what are we doing today, Mr. Speaker, sir? To address the problem of the UNHRC. The bill that we hope will be adopted today, by that bill, once it is adopted, we address the first problem, that is the main problem, the fundamental problem, that there would be no requirement for a candidate to declare his or her community to be able to stand as a candidate. That requirement will be done with, and that is the main requirement. That was the complaint of Résistance et Alternative, and that is the main thing that they say. Violation of the human rights, because you're not, it's a fundamental right, you're not allowing them to stand as a candidate, because in any country they should be allowed to stand. And when we do this, we will not be in violation of Article 25B. We are providing, in fact, an effective remedy to that violation. That is the crux of the matter. Point 2, they say, the point 2 that they say that you have to reconsider. You should reconsider the BLS, the community-based electoral system. But that is precisely what is going to be addressed by the electoral reform later on. The main thing, the important thing now, is to stop the violation of 25B. That is what we are doing. Once we've done this, then with the electoral reform, we will be subsuming the best of the system. It will not be a community-based electoral system. So if we do this now, the question of updating the 1972 census doesn't even arise. We won't need it. It is as simple as this, Mr. Speaker, sir. And the alternative of updating the 1972 population to reflect population mix is not going to be on. Now, Mr. Speaker, sir, I ask myself, really, really, honestly, I'm not being rude or something, but honestly, do you really believe, who in his right frame of mind can even think of asking us to redo the 1972 census? It would be a Pandora's box. I don't know whether you've read this. Even the 1991 judgment I mentioned, you will see that there's a quotation. They make remarks about which communities they are in Mauritius. They subdivide the community. Is that what you want for Mauritius? It would be a real divisive solution. It cannot be accepted. Honorable Samia has a point, which I will grant him, when he argues that the United Nations Human Rights Committee did propose that as one of the 2 alternatives. It is a melting pot. You don't agree on this, but you agree on that. It's good. You can come together. The second one being to have an electoral system that is not based on communities. Mr. Speaker, sir, I must say, I cannot even imagine how can people say this. In 46 years of independence, we're going to start a census. Both the Honorable Leader of the Opposition and myself, we have stated in no uncertain terms and right from the start, that is totally out of the question, and I'm glad because they are the main opposition party. We simply cannot do this in modern Mauritius, 46 years after independence. It would be retrograde, it would be reactionary, and it would be a repugnant alternative, Mr. Speaker. And as has been argued by Sachs, by Carcassonne, by Mr. Ramastanen, there are good alternatives to ensure broad-based rainbow representation in the National Assembly. There are alternatives. And this is what we are going to propose with the electoral reform which is being finalized. Honorable Gambo said that there will be 2 categories of candidates. Those who will declare the communities will participate in the allocation of the additional seats, while those who actually do not declare, they will not participate in the best room, they will not get best room the seats. And I must say, Honorable Gambo is right, absolutely right to say this. It is unfair. I recognize that it is unfair. So what are we doing now? What is going to happen? Those who in fact declare they are Mauritians and therefore they're not going to declare, they will be penalized. But unfortunately, it is inescapable for a very simple reason. I stated by the Supreme Court, Mr. Speaker. The declaration of the candidate community is at the very heart of the best rule system. Now, if a candidate does not declare his or her community, they are forfeiting the right to participate in the allocation of these additional seats. The bill provides for this, but as I say, it will apply for one election, but that is the price we have to pay. There is no other solution. As I say, many people have, but give us the solution. That is the price we have to pay if we want to give the option of a candidate not disclosing his community. In fact, Mr. Speaker, as I said earlier, each one of us, we have a duty towards the actual requirement of the Constitution. We are elected members of the Assembly, and we are going just to flout our Constitution, just to make it difficult for others, just to create communal problems. That is my plea to you. Think again. Because if you do what you're saying you will do, not all of them said, I know Honorable Sudan will declare. Because if he doesn't declare, he will be out anyway, will be more out. No? You'll be in. Okay. Good luck. Six is enough. It will apply, as I said, for one general election only. That is why it's a transitional provision. In fact, each one of us, Mr. Speaker, sir, we have a duty towards the requirement of our Constitution. Schedule 1 of the Constitution is unchanged, and it remains paramount. Section 4(2)(b)(1) and 2, they must be read in conjunction with paragraph 5 of Schedule 1. They cannot be read in isolation. Those who are saying that they will not declare the community will be going against, therefore, the Schedule 1, against the Constitution. That is what they will be doing. In fact, if they do this, is that they don't want the system to work. They want to create all these problems I've been referring to. But this is precisely, Mr. Speaker, sir, why we have put in such a mechanism instead of just changing the words. But we must not forget, Schedule 1 of the Constitution is overriding. There will always be people, Mr. Speaker, who will never propose solutions, never. But they will be quick to find problems, what problems they can create to prevent the solution from working. That is what we're having, for obscure purposes, for God knows what. But as I say, there is no ideal solution. There can never be. But because of doubts created, I've decided to move the amendment that has already been circulated. Now, Honorable Gabo also proposed the alternative of appointing, if I understood him properly, best rule the seats to the most successful unreturned candidates, irrespective of communities. I think that's what he proposed. I was listening to him in my office. Unfortunately, this will be against the provision of the Constitution, which says that the seats must be allocated to the appropriate community. Therefore, we cannot do it. In the language of the Constitution, that it has to be distributed to underrepresented communities after the results of the first past, the seat to elected first past the post alone. And a quick calculation of the results of the 2010 elections would show that many of these seats would not have gone to the appropriate communities if we had done it. Unfortunately, it's a good, both points were good. But unfortunately, we cannot do it. The alternative of allowing party leaders to choose who to appoint as best users, I think I've referred to this, but it is preposterous under these circumstances. In fact, it is the worst proposal I've heard. Because not only it goes against the very provision of the Constitution for a fair and adequate representation of each of the 4 communities, but introduces an element of subjectivity, partiality or discussion in the allocation of these seats. If we change the whole system with a new electoral system, that is different. But not now. Today, these seats are determined in an objective and rule-based manner by an independent institution, which is the ESC. Now, how would one determine who will obtain the first seat, who will obtain the second seat, and go on until the 8th seat? How can one balance the formula to avoid that the will of the people is not frustrated? impossible, and therefore cannot even be contemplated. Others have said, why do we not proceed to the full electoral reform now and now to wait for the next? I've already mentioned this, Mr. Speaker, sir. We want to have a clear mandate because I think the people of Mauritius have the legitimate right to see what we are proposing. I'm sure some will criticize it, I'm sure, but at least we need a mandate to go ahead. The reforms currently being finalized, Mr. Speaker, sir, constitute the very significant changes in the voting formula of our country. In the consultation document itself, there are at least 10 major policy decisions that have been proposed. Plus there are other spillovers and consequences. This is certainly not a simple change in an ordinary law. It is not a change in the tax law. It is a change of the Constitution and the electoral system. And remember, the best through the system, I think Honorable Ganu reminded me of it. The best through the system when it was put in our Constitution was meant to be, for the most, to apply for 3 elections. What has happened? 10 elections, we are still with the same system. So, as I say, this new electoral reform bill, it may well be with us for a very long time. So the people have a legitimate claim to have a say in the process. That is why we want to get the endorsement of the electorate. Mr. Speaker, sir, I believe I've replied to most of the major points that have been raised, and I hope against hope to have cleared the misunderstandings, and I hope you have understood that whatever your quarrel, we must look at the national interest and not differently. Some have spent their time trying to divide. We know this, Mr. Divide and Rule, while others hail from political parties which will be forever belong to the dark ages of history as far as the national unity of the Mauritian nation is concerned. Mr. Speaker, sir, I'm proud and honored that I lead a political party which has always been on the right side of history as far as the emancipation of the nation is concerned, as far as the emancipation of our society is concerned, and as far as the emancipation of our people is concerned. While others want to instrumentalize our natural human differences, and they're very little, I've said it so many times, 99.9%, you are like me, but you won't agree. But they're trying to play on this different for sheer cynical political calculations. I am driven by a dream, the aspiration, the unbending resolve to keep strengthening the notion of a common citizenship, a common sense of identity, and a common destiny, Mr. Speaker. This is why I set up the pilot project for the National Institute for Citizenship Education, which is doing very well, very popular. It's a nation-building program for the youth of our country to build a strong sense of patriotism so they know about their rights and their duties as citizens of this country. We want to build a common sense of identity and destiny, Mr. Speaker said. It is very, very important that we do this. And I see some of us want to do exactly the opposite. When I heard Honorable Perrault, I don't want to be unkind, but I have to react to what you've said because it's untrue. I don't know whether you were encouraged by your leader or not, but I was surprised and sad, I must say. I must say because I didn't expect this from her, but now I know. Because if you read our Constitution, if you just read our Constitution, you will see that the founding fathers of our Constitution, all of them, they bent backwards to ensure that all communities in our rainbow nation are treated equally without any discrimination. I've had, when she says, Mr. Speaker, sir, that, and it's terrible. This is the most dangerous thing that can happen in this country when a member of parliament utters these words. You must be more responsible. I know you're young, but you must be more responsible. When she said that one community is being penalized for jobs in government, I find this unbelievable. We do not live in the perfect world. Yes, carry on.
Any point of order? I have my speech in front of me. I just want the Honourable Prime Minister to show me where I stated that only one community is being penalized. Thank you.
What you said, and on television also you said, can you? I'm responding to.
Yes, I don't think it is a point of order, but you have the right for a point of personal explanation.
A point of personal explanation then.
I'll answer you when you make your point. I will tell her to go and look at the Constitution. Why do you think a Public Service Commission has been created and put in our Constitution? Why do you think the DFSC was created? And who names the members of the PSC and the DFSC? What's your friends now? Your new friends? Who named? I agree with her, we do not live in a perfect world. There will always be people, Mr. Speaker, sir, who discriminate in every country in the world. Well, there is no discrimination in America, there is none in the UK, there is none in France. In every country you have. But to say that some people are getting jobs and others are not getting, that is not. You've seen it on television, you've said it, in public. But our founding fathers, Mr. Speaker, sir, gave us a constitution which guarantees the fundamental rights modeled on the Human Rights Convention. I've had lawyers, top lawyers coming from England looking at our human rights. They're amazed. And they've told me, and I know, that our constitution, in fact, if you bother to compare the constitution of Mauritius with those of the Commonwealth countries, you will see our constitution is unique in the Commonwealth. Just go and compare. There are many things are common, but ours is unique. But I agree, we have to strive to eradicate unfairness everywhere where we see it. That I totally agree. I've always believed, Mr. Speaker, sir, that all humanity is one. Whatever our origins, our color, our religion, our I don't know what else, community or what. It is an ideal that I say I will fight for always. This is why I went even further. I set up an Equal Opportunities Commission so that each and every citizen can feel that they get an equal opportunity to thrive and attain his or her goal. And it is working. I set up a public bodies appeal tribunal against the advice of the civil service, I must tell you. They do not want to hear about it. They think I'm doing something that will create all sorts of problems later on. I went against that so that if you feel you are discriminated against, you can have a quick redress instead of waiting to go to the courts and wait for 10 years or whatever. I set up the Truth and Justice Commission to close the deep wounds of our past. We need to heal, Mr. Speaker, sir. And I never, never have or never will leave any stone unturned to rally, to rassembler all Mauritian citizens around this one common sense of destiny and identity. This is why I find it absolutely shocking that anyone today in 2014 could suggest that we start counting, categorizing our population in rigid, hermetic, straitjackets as if, which is the surest way. It is the surest way to stifle the flourishing, I should say, of the fluid citizen-based common identification of the nation. That is the surest way of doing it. Needless to say, Mr. Speaker, sir, I most vigorously denounce such historically retrograde ideas. And I will never cease to forcefully fight against such evil-minded propositions, which are downright dangerous for the social harmony of this nation. The Labour Party, as I said, always stood for progressive values and the advancement of all Mauritians as a cohesive and united nation in all its diversity. We will continue to uphold these principles. And, Mr. Speaker, sir, when we see what has happened, when I say this, some people take exception, but it is a fact these are the two bigger parties in Mauritius. It is a fact. Just look at all the results you want to look at. But no one should be surprised. No one should be surprised that the Labour Party and the MMM, when national interests are at stake, they tend to converge on that point. We have our differences. Of course we do. Two big parties, you don't expect to have differences? In my own party, there are plenty of differences. And I'm sure in theirs too. That is what democracy is about. But when the national interest is concerned, That has been the case, and it is being the case again. So you're surprised that we're coming closer together and they're pushing you off? Because you are retrograde. You cannot standing for what modern Mauritius should be. That is why there is convergence, Mr. Speaker. But I know what your wish is, but it won't happen. Your wish, not my wish, your wish.
The your is not your.
But let me conclude, Mr. Speaker. So I want to borrow a paragraph from what is known as the Duty, Honor, Country speech by John MacArthur. Look what he said. He said, duty, honor, country. Those three hallowed words reverently dictate what you ought to be, what you can be, and what you will be. They are your rallying points to build courage when courage seems to fail, to regain faith when there seems to be little cause for faith, to create hope when hope becomes forlorn. The unbelievers will say that they are but words. That's what they will say, they are but words, but a slogan, a flamboyant phrase. Every pennant, every demagogue, every cynic, every hypocrite, every troublemaker, and I'm sorry to say some others of an entirely different character, will try to downgrade them even to the extent of mockery and ridicule. But everyone knows, unquote. And we see, I've used these words because we can see what is happening here, Mr. Speaker, sir. And, Mr. Speaker, sir, just to make sure I don't forget, everybody knows I stand for unity. Everybody knows this. Under my watch, Rainbow Nation unity is the key, are the key words. I've always ensured this, Mr. Speaker, sir, but exceptionally, just to make it clear, exceptionally, because I respect the Constitution, because I know the Constitution is there, I have to respect it. Exceptionally, from this one example, from this one election, these transitional provisions will be there. I intend, and my party intends, to respect the Constitution, and we will therefore remain faithful to the Constitution. For that election only, we will declare our community. We have to. There is no other way. Everybody knows, Mr. Speaker, sir, that throughout my political engagement, just like what is happening, we see sometimes happening to the honourable leader of the opposition, I have never been spared any criticism, justified or unjustified, but I have not been spared. Whether based on facts or sheer myth-making, slander on my character, in spite of all this, Mr. Speaker, sir, I proudly stand here even stronger in my unflinching aspiration to rally the whole Mauritian nation out of the common sense of identity and destiny. That I have no doubt. To lead our country to an ever brighter future, especially for the younger generation. I stand even stronger in my resolve to shape the future of this country so that the young of this country will for a long time continue to sing the praises of this country and the fact that we are one nation, one people, and we have one destiny.